Welcome, everybody. We are going to give everybody a few minutes to get joined in with us, but you are welcome to go ahead and start putting questions in either the chat or in our Q&A box, whatever is most comfortable for you. I'll have those available to me to ask Michelle throughout the webinar. Again, thank you so much for joining us today. We're really excited to get started. So if you'll just bear with us as we give everybody some time to join the webinar. Thank you. Welcome, everyone. All right, I've got a few more people coming in through our waiting room. Welcome, Michelle. All right. Okie dokie. We'll go ahead and get started. Welcome, everyone. We are going to be doing the Divorce Foundation series, a one-on-one guide to Washington state family laws and what to expect with Michelle Dellino. As I mentioned earlier, you're welcome to provide questions in either the webinar chat or in the Q&A section, wherever you are most comfortable. As Michelle is going through the live webinar, I will be providing her questions. So feel free to interact with me that way. You can put the to host and panelist, and I will be reading those to Michelle.
Great. All right. Well, before we get started, hi, I'm Michelle. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we help clients all over Washington state. So what we do is all kinds of family law. Sometimes that's divorce, sometimes that's post-divorce, but today we're going to talk about divorce basics. If you're here, you're either thinking about a divorce, you're in the middle of a divorce, or you're at the beginning, or maybe you're after, and I don't know why you'd want to relive it, but maybe you do. I don't know. Anyway, so you could be at any different stage, and that's really important for you to know. So I'm going to talk about a general overview, and that may or may not pertain to your situation, depending kind of on what stage you're in the process. Before I get started, I will let you know that I'm an attorney, but I'm not your attorney. Nothing on this webinar should be taken as legal advice. Legal advice can be given when you have an established attorney-client relationship directly with an attorney and never in a public forum. So if you are watching and you are my client, then this isn't the place to ask for advice, but you probably already know that. So what I'm here to do today is hopefully have you leave with more information than you came with. So you're going to leave with a better understanding of what the main issues are in divorce, what that might look like, and some other things to think about as you move forward in the process, hopefully to help you make things easier. The idea of this series really is to give you a foundation, to give you something to get a little more familiar, even with just the literacy of divorce. There's its own words, there's terms, there's things you need to know. And sometimes you need to hear things a number of times because it's really a different language. So hopefully this will help with that. If you have questions, like Gabriella said, you can send them to her. I will pause at different times as I move through some of the topics to see if there are questions that you want me to answer. I will also say this before I start. The more fact specific that your questions are, like if you have a detailed hypothetical that you're giving us, it's gonna be really difficult for me to answer that. And if you have those kinds of questions, you should probably consult with an attorney one-on-one on your own, or talk to an attorney that you're working with. If you do have questions like that, I'll do my best, but I might just be able to pull out sort of what the bigger issue is and address that rather than go through a whole fact-intensive hypothetical for you. So I'll do my best to get some of your questions answered and leave you with more information than you came with. So on that note, let's talk about divorce in Washington. When I talk about it, I really like to, really the best thing is to start from the beginning, and we'll talk about who can file for divorce in Washington. The basics will basically be who can file for a divorce. What does that look like? What's required? Do there need to be grounds for divorce? What's the waiting period like? What are the issues in divorce? Do I need an attorney? We'll get to all of that. So I'm going to start where we start, which is in the very beginning. Who can file for divorce in Washington? There is a residency requirement. So why does this matter? It matters because at least one spouse must reside in Washington state at the time of filing. It's not uncommon sometimes for the other spouse to move out of the state, but you need to understand that somebody needs to reside in the state at the time of filing. And that doesn't necessarily even mean that there's jurisdiction over both spouses. So we'll talk about jurisdiction in a minute. So Washington's different than some other states. We don't have a minimum residency period, which means a spouse can file for divorce really as soon as they move here and establish residency. They could go get a driver's license, get a bank account, register to vote, any of the things that you do to establish residency, and then they could file immediately. However, if you just moved to Washington and then the other spouse doesn't live here, you were never married here, they've never been here, that you didn't live here during the marriage, there's no ties to Washington, there probably is not jurisdiction over the other spouse, and it might not be the appropriate place to file for divorce. Just because you can file for divorce here doesn't mean there's jurisdiction over both parties. I want to mention jurisdiction because this is a word, it's a word that you might hear in a lot of different contexts, and I just want you to know what it means. Like, what does it mean in this context? It means if a court has jurisdiction over you, it has the ability to enter an order that you have to follow. So if you've never, let me give you an example. If you've never been in the state of Maine and you're married, your spouse moves to Maine and you're still here in Washington or somewhere else, and then your spouse files for divorce in Maine and serves you with the petition, the Maine court has no authority to order you to do anything. Like, they can't enter orders saying you have to give this much property, you have to pay this, you have to do that. They can't do anything because they don't have jurisdiction over you. So jurisdiction means the court's ability to have the authority to enter an order over you that's going to make you do something. So if your spouse has no ties to Washington, there might be a more appropriate forum for divorce. You're really going to need to talk to somebody about that. But residency requirement and jurisdiction is kind of the first thing you got to think about. For a lot of people, that's not an issue, but for some people it is. Other issue related to that is children and jurisdiction. So it's not uncommon for couple, let's say you live in Washington and then you move to a new state and somebody just moved there. So generally speaking, your child needs to be in a state for 6 months for that state to have jurisdiction over it. So what that means is if you move to Washington and you've only been here 2 months, there's probably not jurisdiction, and you have kids, there's probably not jurisdiction by the court to enter a parenting plan over your children. So that's where it gets complicated. Have both parents moved here and you guys agreed that Washington's the right state? Is the other parent staying in the other state? That's probably where jurisdiction's going to be, depending on a lot of things. So children and jurisdiction with children requires that they be in the physical state for 6 months before a parenting plan can be entered, unless there's a reason for emergency jurisdiction, you're trying to get away from domestic violence or any number of other things. So that's just something to note. And that's something you're going to want to talk to somebody about if that's your situation. So think about that. Have your kids been in the state 6 months? If so, then you're good to go. If not, you might have to look at what's going on. Okay. Grounds for divorce. So we talked about residency and who can file for it, but you have to have grounds for divorce. I mean, some people in some states you do, and those are called fault states. There's very few of them left. I think maybe there's 3. I don't know. But we are not. We are a no-fault state. So you might hear term no fault, just like you might hear the term jurisdiction. This is kind of part of the vocabulary. A no-fault state means the only ground that is required for you to file for divorce is for somebody to say the marriage is irretrievably broken. I've had clients, not very many, but I've had clients in the past where the other party serves them this petition, and all they say in there is the marriage is irretrievably broken, and that's their position. And then I've had clients in the past where they'll say, well, I don't agree that it's broken. I think we could fix it. We should go to counseling. I don't agree, because they don't want to get divorced. Only one person has to claim that. So with one person having to claim that, you know, it doesn't matter if the other person agrees. And unfortunately, that might be something, that you don't want to hear, or that isn't, that isn't what you agree with, but there's no reason to prove fault. It's not a situation where you have to prove someone was cheating on you, you have to prove domestic violence, you have to prove any of those things. Anybody can get divorced simply because they want to. And that's actually, that's actually a good thing if you think about it. You don't want to be forced to stay married to somebody that you don't want to be with, and they don't want to have to be forced to stay married to you. But it can be a hard thing for people to understand. So like to point that out for you. Okay, the next thing to think about, and we'll move forward in this process, and I will stop in a minute and take some questions. But the idea here is for you to know, here's the hoops I've got to jump through to move forward. Okay. And then here's the things I have to decide once I'm in it. So right now we're in the first part. What do I have to jump through to move forward? I got to live here. There has to be jurisdiction over me, my kids. I don't have to have a reason. Nobody has to do anything. Nobody has to prove wrongdoing. Okay. So those might sound like very basic things, but you'd be surprised how, not basic they feel to some people. And that's a very real concern. The next question, and this is not the same in every state, is the waiting period. How long do you have to wait to be divorced? And here's the fun thing about that. A waiting period is not the same thing as if you ask me realistically, how long is this going to take? Because pretty much everybody wants their divorce over right away. Everybody does. Everyone's like, I just want this done. I want to rip the Band-Aid off. I want to be done. That's normally what anybody would say. But how long it's going to take is different than what's required, what's the waiting period. So waiting period, once someone files for divorce and serves it on the other party, there is a required 90-day waiting period in Washington. So some people will call it a cooling period, but it's a waiting period. You can't finalize your divorce, even if you've agreed on everything and signed off on it. You cannot finalize your divorce any faster than on the 91st day after filing and service. So here's the reality of that, though. 90 days is a really fast divorce, unless you've negotiated everything ahead of time, unless everything is done. And sometimes we have cases where a petition isn't filed until everything is negotiated. Sometimes that happens, but more often than not, a petition is filed and then the work begins from there and people begin negotiating. They might have a temporary status quo in their case for a while and they go from there. So 90 days is very, very fast to get everything done. Even in divorces that I would call cooperative and not highly contentious, you still have to, a lot of things need to happen. You have to think about it like this. Getting divorced is the undoing of the most complicated legal contract you're probably ever going to enter into with another person. You didn't have to do a lot to enter into it, but you do need to make sure that you're handling it in the best way possible as you exit it. And that's going to take longer than 90 days. So how long is it going to take? You're probably wondering, am I going to get to that? It depends. There's a lawyer answer for you that you might not want, but it's very realistic. I also, too, don't believe in telling people what they want to hear. I'd rather tell you what's realistic and more likely to have happen, or at least a range of risk for that. So if I tell you, if you want to hear that you can get divorced on the 91st day, but you don't agree on anything, and I'm like, yeah, we'll get you divorced on the 91st day, that's not setting you up for any kind of realistic expectations, and it's going to make things more painful for you. So I wouldn't tell you that. Instead, I would tell you, if you are in King County, like if you were here in Seattle in King County, and you've got things to work out, you've got assets, you have kids, maybe just one of those things, maybe you have both. A short divorce in King County would be getting things done in 6 months. An average time, I think, more likely is 9 to 12. If you have a more hotly contested case, you're going to end up in a trial, or at least you're going to have, a lot of things happen before you're able to settle the case, probably longer than a year. So it's important for you to know that a divorce is a marathon. It's not a sprint. There might be a little sprints along the way, but it's definitely not, it's not going to be done in 90 days unless everything is either very easily agreed upon or you worked it out ahead of time before filing. So that is the important thing for you to know. The 90-day period initially, some states it's a year, some states it's any number of things. It's supposed to allow time for negotiation or reconciliation. Very few people do reconcile, but you can, it makes me want to mention to you, you can reconcile and withdraw your petition at any time. So if you file and you guys get back together, you can definitely do that. If there's disputes over custody, assets, support, process is definitely going to take longer than 90 days, like I said. The last thing I want to mention about the waiting period is the difference between legal separation and divorce, okay, in waiting period, and how filing for one, it impacts the other. So here's how to think about that. If you file for divorce, you can finalize after 90 days, but you have to wait the 90 days, and then you're divorced when you do finalize. If you finalize a legal separation, there's no waiting period. So sometimes, like if you are getting legally separated, and I'll tell you more about what that means, you could finalize it, in a week. You could finalize the next day. But once you finalize a legal separation, there is a 6-month waiting period before you can convert that legal separation to a divorce. So no initial waiting period for legal separation, but 6-month waiting period to convert it to a divorce if you choose to do so later. So some people want to know, why would I go for legal separation? What's the difference? In a legal separation, all of the same things happen. You divide assets, you divide debts, all of those things happen. You have a parenting plan, there's spousal maintenance. It's pretty much the same, except for the fact that you're still married at the end of the case. However, you are financially separated. So for IRS purposes, you're going to file your tax return as single. Um, One reason that people do legal separation is some people simply have religious differences and don't want to be divorced. So that is a reason I have seen. But the more common reason that I see is if you want to keep the other party on benefits for a period of time and your employer allows you to do that post legal separation, you might go legal separation to keep them on benefits longer. Sometimes the thing to know, though, is not all employers do it. Some very large employers in our area realize that legal separation means you're financially separated from that person and there's not, a dependent relationship there and there's no longer a marital community there. So they terminate benefits with a legal separation. So if you want to do that, you're going to need to make sure that you understand why you're doing it and make sure that it accomplishes your goals. And yet another reason is sometimes it's just easier and more palatable for one person to come to terms with a legal separation. So it's more of a step towards the acceptance for one party. Or maybe there's more hope that you're going to reconcile. However, it's the same process for legal separation or divorce. You can withdraw either petition, so that doesn't necessarily matter. So I will pause for a minute. And Gabriella, is there any questions you want me to answer?
Yeah, we've got three questions all surrounding temporary maintenance. So the first one is, how is temporary spousal maintenance calculated or determined?
Okay. Well, I'm going to get to talking about temporary maintenance in a minute.
Mhm.
Anything else? Because
Let's
that's going to take
see.
me down a path, so I'm not going to go
Yeah,
into that. I'm going to talk
right.
about today.
No, I completely
Yeah.
understand. Yeah, the next one is also about financial responsibilities, specifically regarding a legal duty of support. So kind of going back into shared
Maintenance.
finances and maintenance.
Mhm. Okay. Okay. Well, maybe then what I'll do is if there's not anything that's not related to finances or maintenance, I'll just jump right in because that was my next topic. Anything
Sounds
else?
good.
No?
No, those
Okay.
were the main topics.
Good. All right. Well, we're about to talk about the four main issues in divorce that everybody has to deal with. There's two everyone deals with, four you deal with if you have kids. And then there are what I would call collateral issues to each one of those, like an ancillary issues. So property and debt division, asset and debt division, that's number one. Spousal maintenance is number two. I'm not saying spousal maintenance because there's spousal maintenance in every case, but there is a question that has to be answered in every case as to whether spousal maintenance should be awarded. So that's in every petition for every divorce. So you have to deal with how you're going to divide the debts and assets, and is there going to be spousal maintenance? You have to do that in every case. The other two issues that we'll get to after I talk about the finances are parenting plans and child support. If you have children under 18, you cannot get divorced without entering a parenting plan and child support order. So we'll get to that too. But let's kick it off talking about asset and debt division. And I know everybody wants to know about maintenance too. You really cannot talk about one without talking about the other in Washington, and I'll tell you why. So, all right. Community property. There's another common vocabulary word that you're going to hear, and it's important for me to define for you what that means. So, what is community property? I mean, I don't know. If I was asking people to raise their hands, I would, but we're not in that kind of setting. So what is community property? Community property is every asset and every debt. Community debts and assets are all community. And they started from when you got married until when you separated. That's it. And that's everything. And sometimes that community period starts before, if you started continuously cohabitating before you got married. So what is it? It's any income that you make at any job. It's money you put into a retirement account during that time from your wages. It's any assets that you buy. It's any homes. It's all of it. What's not in that circle of community property? If you got an inheritance that was just to you, if you got a gift that was just to you, or if you have income during that circle that is from a separate property source, okay? Now, there's two kinds of property, separate property and community property. These are things you need to take away. Okay, community property, I just told you, it's everything that's earned during that time. Separate property is, like I said, it's inheritance, it's gifts, or it is income that is earned from a separate property source. I'll give you a really common example, and if you've watched these before, you've heard me say this, where I had a rental house, this comes up all the time. I had a house, I owned it before I was married, and then I rented it out, and now I'm married and I'm living somewhere else. But my spouse had nothing to do with that house, and it's my house, and it's generating rental income. That income that I'm making during the marriage comes from a separate property source. So even though it's income and income is community, that is separate property income. Okay, it's separate property because it comes from a separate character. Another common one is investments. If I've got a taxable account and it doesn't have contributions during the marriage, or even if it does, it's still earning interest income from a bunch of money before the marriage. That interest income, separate property. So those are a couple examples. I won't go too deeply down this train, but something to know too, and this is really important, the character of property, whether it is separate or community, is established at the time it is acquired, unless it changes. So if I buy a house and it's during the marriage, it's going to presume that that is community property. If I move out later and my husband stays living there and we're getting divorced, it doesn't mean that's not my house anymore because the character of it was established when it was acquired. There's ways you can change property from separate to community or community to separate, but that requires another process that's probably for a more advanced webinar. Let's put it that way. So once you know what's in the community, you figure out what it is. A rule of thumb is most assets and most debts acquired during the marriage are community. Then you have to talk about how to divide it. So we are not a 50-50 state. Some people think community property means it gets split down in the middle. In some states it does. In Washington, it does not. The standard for dividing property in Washington is supposed to be what's just and equitable. What's equitable? I like to use that word better than fair because fair is so it's just not objective. So equitable, what does that mean? What it means is that to decide how that community is divided, it's really going to depend on a couple of different factors. How long were you married? What's the length of the marriage? And what's the financial situation of each spouse when you're getting divorced? That's going to include things like what's your income right now? What's your education level? What's your ability to get other work if you're not working? What's your future earning potential? What contributions did somebody make to the marriage if they stayed home while to raise kids or something like that? So situation of each spouse at the time of divorce and the duration of the marriage. You're going to look at those things, and that's going to help guide what a reasonable division of the community is. So if you guys make about the same amount of money, you're in a short or midterm marriage or long-term marriage, everything is all equal, you're probably going to be pretty close to 50-50. If one person stayed home and you're in a 20-year marriage and one person hasn't worked and the other person's the breadwinner, the financially disadvantaged spouse is going to take more of the community. They are going to take what's called a disproportionate share. And you might hear that term as well, disproportionate share. Somebody's going to get less or more of the community, right? And someone's going to get more if they're not going to financially recover as fast from a divorce. So maybe they're going to get 60%, maybe they're going to get 55%. Hard to say, but it's going to depend on those kinds of factors. And in that situation, you look at, is it a short term, a midterm, a long-term marriage? There's a lot of different things to look at to have an idea on what the ballpark is on how the community will be divided. Separate property owned before marriage, inheritance, gifts, everything I was talking about earlier, typically stays with the original owner. But in a long-term marriage, 25 years or more, separate property can be divided, and there is a principle of equality in a long-term marriage, so it very often will be looking at the big picture. Or it might mean, in some cases, to do equity, that one party gets more of the community because the other person has a lot more other assets to help them. So anyway, bottom line is separate property usually stays separate, but it can be a factor in how to divide the community. So that's important for you to know. So you're probably wondering, like, why does this have anything to do with maintenance? Well, it does. You really can't talk about one without the other, because Washington is very much what I would encourage you to think of as a choose your own divorce adventure state when you are structuring a settlement. There is not a certain way that you have to do your settlement. It doesn't have to be, I'm dividing the property on this spreadsheet this way, and I'm getting this much maintenance. You could do No maintenance and a larger disproportionate division of assets. You could do a lump sum payment of maintenance out of the property division, and you could propose a slight discount for prepayment because the value of getting that money up front is greater because you're going to be able to invest it. You could do less property and longer maintenance. You could do any number of things. There's guidelines, like I told you, about dividing the community, and then there's general guidelines for maintenance. But what you need to know about maintenance is we don't have a statutory formula in our state where you plug in, I make this much, she makes this much, this is how long we're married, boom, here's the maintenance formula. It doesn't work that way. What we do have, though, is we have general guidelines that I can tell you, they're not hard and fast. I've seen a lot different types of outcomes, but in general, every 3 to 4 years of marriage is equal to 1 year of post-divorce maintenance. So that's a guideline. And like if you were thinking about, like, let's just say you were thinking about like a 16-year marriage, okay? So 16-year marriage, like on a 3-to-1 ratio, you'd be looking at a little less than 5.5 years of a little less than 5.5 years of maintenance on the high end and 4 years. So where's your range of risk? If somebody's the breadwinner by a lot and you're married 16 years, somebody's probably going to pay between 4 and 5.5 years of maintenance. That's probably what's going to happen. Or there's going to be a disproportionate division that's even greater if someone doesn't want to pay maintenance or there's a reason for them not to, or any number of other things. Okay. What is maintenance? We should talk about that. Maintenance is a post-divorce payment from one party to the other for support. Someone asked about temporary maintenance. I will talk about that as well. Temporary maintenance is just that. It is a temporary payment for support from one party to the other. Here's the thing to know about temporary maintenance. Depending on how long your marriage is, I'll tell you what, I litigated a case, not maybe a couple years ago, where the other party was trying to get maintenance from my client. I've had a couple of these actually, but this one really stuck out because the other party was trying to get maintenance from my client, and it was a 2-year marriage. And generally speaking, that person's going to get no post-divorce maintenance, none at all. And it was a situation where the other party had moved to Washington to be with my client. My client's the one with the job. And the court, it was the first time I'd had it happen. It was more than a couple years ago because now it's more common. The court limited temporary maintenance and said, this is a very short marriage. You need to get a job. You get 6 months of maintenance and that's it on a temporary basis. And that was a win for my client because here's what I was about to say. In King County, you get a case schedule when you file your case. It's got the date you filed. It has a bunch of other deadlines, most of which are administrative. There's a dispute resolution deadline. It's a bunch of things on that list, okay? But the trial date in your case is a year later, and that assumes that there's no continuances. So what that means, even though your case probably won't go to trial, is that your case can take a while. And if both parties aren't motivated to get settled, someone can really draw things out with that case schedule for quite a long time. So if they're collecting maintenance and they know they might not get as much post-divorce, or they want to extend that period, they could draw maintenance for a year or more than a year. I've seen that happen in many cases in longer marriages. In short marriages, not so much. The court might step in and limit it and say, hey, I don't think so. But temporary support is available if one party has the ability to pay, the other party has the need, and there's actually resources available for it. So there's a number of things you need to know about when temporary support happens. So in really in any county, but I'll just use King for an example, you can file a motion for temporary orders. When you do that, what you're doing is you're saying, I'm asking the court to give us a set of temporary orders and like a new status quo while this divorce happens. Because I told you earlier, divorce could take 9 to 12 months. It could take longer. You've got to know who's paying the bills during that time. Am I getting support during that time? Is there a parenting plan during that time? Is there child support? There's got to be some kind of stability. So temporary orders can really give you some stability while you work out final orders. That's kind of the idea. Sometimes you can agree on what temporary orders can be, and you don't have to go to court to have someone decide it for you. Other times, you can kind of agree on a status quo and you might not need an order to formalize it. And yet other times, you might even go to a mediation to mediate those temporary orders. That's not always done, but it definitely is in certain circumstances. But very often when people can't agree, somebody files a motion, they set it on what we call the family law motions calendar in King County, and they go to the hearing. Everybody has filed stuff in advance. Court knows your position. They let the attorneys argue for 5 minutes and then they make a decision. So that's what happens. And whether you're going to get temporary spousal maintenance, temporary child support, or the parenting plan that you want is really going to depend on your current financial situation. And if you're not working, why are you not working? Are you voluntarily unemployed? Or did you just get laid off? Have you been looking for a job? Like, what's the situation? And what is your need? You're going to have a financial declaration that's before the court. Anytime that you go to court and you ask for some kind of monetary relief, whether it's spousal support, child support, attorney's fees, no matter what it is, you're going to have a financial declaration about your expenses and supporting financial source documents before the court. So they'll evaluate what to do and they'll make a decision. So anyway, long story short, temporary maintenance is available, and temporary maintenance generally does not count towards post-divorce maintenance. So my point being, you could pay maintenance for a year on a temporary basis, and then you could still be ordered to pay, let's say, your 12-year marriage, 3 or 4 years of maintenance, and they're not going to give you credit for that 1 year. That's just temporary support. So I know there were other maintenance questions, but that gives you a flavor for asset and debt division and spousal maintenance. I'll take a couple of questions on that before I start talking about parenting plans and child support.
Sounds great. Thank you, Michelle. There's several questions definitely, so I'll try to combine them where I can. One person asked if bonuses are included in income when it's being calculated for
Yes.
yes, go ahead.
Yes, that's an easy one. Everybody wants to know that. So that's a great question. When you're talking about income, like for purposes of maintenance and child support, all income is generally considered. You can't double dip. So, like, let's say you have, and this, you kind of get into this more with asset and debt division and restricted stock units. You can't double dip and award somebody a bunch of RSUs and yet still say that they should be the basis for paying maintenance or child support. So, there's different ways to look at that when you're at a final disposition. But generally speaking, yes, all income is considered, and that includes bonuses. If you have a bonus and everybody says the same thing. Everyone's like, I don't know if I'll get it next year. It's different every year or whatever. You really have to show that it's not likely to be recurring. And on a temporary basis, if you earned it, it's more likely than not that it's going to be considered all income. All income is income. So just generally go in expecting that income is income unless your job has changed, or unless you can really show this was a crazy one-off and I'm never going to get a bonus, or unless your bonus eligibility has changed or something like that.
Great. And so one of the next questions I have is I want to start the divorce process. Can I pull from the community property to start with rent for a new place, etc., for my new life?
Yeah, I mean, here's the thing. It depends. If no one has filed for divorce and you have access to community assets and you choose to use those to move out, I mean, you're not doing anything wrong. It's community money. You have an interest in it. If you have already filed for divorce, there is something called an automatic temporary financial restraint in place. I should tell you guys what that means, and I will. But the thing there is, you can still use community assets for an apartment, for food, for living, for utilities, for all that kind of stuff. But if it's going to if it's going to be in dispute, and you don't have access to the money, you probably are not just going to tell the other party, give me $10,000 to put down first and last and buy some things for my apartment. They're probably not going to agree. So you might have to go to temporary orders to ask for access to do that. But if you haven't filed for divorce and you have access to the community and you want to move, I mean, there's nobody to say what you can and can't do with your money. However, that said, if you have access to the community and someone's about to file for divorce and you haven't, and you wipe out the entire community bank account and take all the money out of there and put it in your own account and won't give anybody else access to money, the optics of that are going to be bad for you. So you have to be reasonable. It really depends on like what you have, what's available to you. If you need $10,000 to get set up in a new place and that's all the community has, probably not reasonable. If you know, I would say this. If you need to move out and you don't have access to money, you're probably going to need temporary support anyway for that to be ongoing. So that should be probably something that you do and seek when very close to the time that you file or soon thereafter.
Awesome. And then we have a few people that have similar situations but different. But essentially, there's one spouse that is either unemployed or was formerly employed with a high salary and now are choosing not to work.
Mhm.
How does it affect during temporary orders or even after finalized divorces if spousal maintenance can be changed after that person either gets a job or continues to choose not to get a job?
Yeah. Well, here's one thing to know. You can't just, you can, but it's not smart to, oh, I quit my job and I'm voluntarily unemployed. So, voluntarily unemployed, if you've been a stay-at-home mom, you're back, it can be offensive to some people, but you're voluntarily unemployed. The court's going to say you have to get a job. Do you have to do it right away? No. I mean, if you've been out of the workforce a long time and this just happened, no one's going to be like, you need to have a job tomorrow. Nobody's going to say that. But there is a reasonable expectation that you're going to have to go back to work unless you're retirement age or disabled. So, at a certain point, if you don't, income will be imputed to you at there's a table for imputation of what you could basically make at, you know, an average job, what someone at your age should be able to make, whether it's 3,500 or 4,000 a month or whatever it is, it's a low amount compared to what you would make if you were out there in a full-time career, for many years. But there is a basic imputation that you may be imputed at a certain point in time. Likewise, I had a case, oh, I think this was a couple of years ago, and it was really interesting because the other party was the breadwinner and had a tech job and also had a master's degree. And in the middle of the case, quit his job and decided he just wanted to go back to school and get a PhD because he didn't want to pay spousal maintenance. That was really why. And this ended up being a trial case. And the outcome of that was the trial court thinking that it was ridiculous and imputing him to his last known income. And he really basically then needed to hustle because that was the basis for maintenance and child support. So he had a $350,000 a year job, something like that, quit, went back and became a doctoral student and enrolled and was like making a stipend of like $12,000 a year. And the court was like, you don't get to do that. And so you could be imputed to your last known income. I'm not promising you that's going to happen for somebody, but it definitely can. It's different in a situation if, let's say, you got laid off and and you had a high paying job, but you can't find another one, and you're looking, you can't find it, and you're looking for months, and then you just have to take something that pays a lot less. You're not going to be imputed to what you were making before because you can show, hey, I tried, and this is what I could get, or I couldn't get a job. That's very different than I just quit and I'm choosing not to work. The position you should be taking if someone's doing that is that they should be imputed. And what that looks like depends on your circumstances. So, yeah.
Awesome. Thank you, Michelle. If you want to go ahead and move into
I
parenting
do.
plans, and then we'll come back to any additional questions at the end too.
Perfect. Thanks. Yeah, I want to get through these. Just so everybody hears a little bit about everything. So, parenting plans. If you have kids, you're going to need to establish a parenting plan. Parenting plans are not decided about what's best for the parent, they're decided what's in the best interest of the children. There is a framework for that is a statutory framework, and the overarching theme is what's on the best interest of the children. So, parenting plans are court orders, but they're also a lot longer than one page. They're longer documents, and they outline some really important things. They outline what we call the residential schedule. So that is the number one thing, where your kids are going to be when. And the thing to know about that, and some states will call it a custody order. We don't really use the term custody in Washington very much. We use the term residential schedule. We use friendlier terms for some reason, just like we don't use alimony. I usually say that alimony is what a lot of states will call spousal maintenance. In Washington, it's spousal maintenance or spousal support. We don't use the term alimony, but it's the same thing. So custody order, parenting plan, same thing, but we use the term parenting plan. We don't say custody schedule, we say residential schedule. So anyway, residential schedule is the main component of the parenting plan. It's going to say where your kids should be when. You should know, however, if you have a super amicable co-parenting relationship, if you guys get along, whatever, even if you don't and you just want to help each other out, you can deviate from the parenting plan as much as you want. Parties can always make other agreements. I think of the parenting plan as kind of the rules of the road if nobody agrees, or if you just have a schedule in there that you like following that works for you. But you guys can agree, oh, I'm going out of town this week. Do you want to take the kids? Yeah, I'll trade. I'll take these days. You can totally do things like that. You're not like, parties aren't forced to following the parenting plan or someone's going to get in trouble. But if one party wants to follow the parenting plan, both parties have to. So Think about that. That's the thing, residential schedule. Second thing it's going to do is it's also going to talk about holiday schedule. How are you going to deal with holiday breaks? Midwinter break, spring break, the longer winter break for kids. How are you going to deal with 3-day weekends, in-service days, religious holidays? All of those things are going to be covered in your parenting plan. There's going to be an answer for everything, or at least there should be in a very clear plan. Summer schedule. In some cases, summer schedule will be the same as school schedule, or you might have kids that aren't school age, and then the schedule will be school age. I'm sorry, non-school age, school age, and then there'll be a question about summer schedule. You might have the same schedule, or it might be something where, kids spend longer time with each parent in the summer, or there'll be a summer break provision for how much vacation time people can take. So school schedule, non-school schedule, holidays, vacation days, summer vacation, all of those things will be decided. The other important things in the parenting plan, this is the number one cause for conflict post-divorce: decision making. Parties have a very hard time accepting, even if in theory they think it's going to be fine, that they have to make decisions with the other party. Right now, like if you're married, you make decisions together about extracurricular activities, doctor's appointments, non-emergency medical things like therapy or braces, or one party just does it and the other party doesn't care, whatever it is, however your family operates. When you're divorced, you have to make those decisions together. They're called joint decisions, major joint decisions. And for a lot of people, that's very hard to do because you now have to make important decisions with somebody that you got divorced from, that maybe you don't see eye to eye on everything with, including parenting. So your parenting plan will have an allocation of decision making. Who makes the decisions? Is it joint or is it sole? And I'll talk about that in a minute. And then if parties aren't getting along, or they can't make a decision, what's the process for dispute resolution? There'll be a process for dispute resolution if you disagree about interpretation of the parenting plan, if you disagree on a major decision, things like that that can be handled through dispute resolution. There'll be a process for that, whether it's mediation, arbitration, or going to court. A good parenting plan also will have an internal process on, I want to propose a decision, other party has a certain amount of time to respond. This is what I need to tell them. This is how it needs to be communicated. Just removing ambiguity. A good parenting plan should remove ambiguity and leave clear processes. So this is all why your divorce is going to take longer than 90 days, because you're going to have all of this in there to make your life better and make your kids' lives better. So courts favor frequent and continuing contact with both parents, unless there is a reason for restrictions and unless there's harm to a child. So what I mean by that is, when I started doing this work a long time ago, it was really common for one parent to be the primary parent with most of the time, and the other parent to have every other weekend. That was a really common schedule. And then things kind of developmentally evolved. And then it was like every other weekend and a midweek overnight. And then it was like every other weekend was no longer Friday to Sunday. Maybe it was Friday to Monday. Maybe it was Thursday to Monday. The time started to expand a bit. Or maybe in the off week, it wasn't just Wednesday to Thursday. Maybe it was Tuesday to Thursday. So bottom line is, there's been a movement towards recognizing that it is developmentally better for children to have more contact with both parents, even if that's not how it was. Like if one parent was I do everything, I'm the stay-at-home parent, I'm the go-to on everything, it doesn't mean that that's the way it's going to stay post-divorce. Both parents are very likely to get equal time with the child if, and again, this goes back to it being in their best interests, if everybody lives close together enough, because you can't have one party living in Everett and the other party living in Tacoma and thinking you're going to do a 50-50 schedule. That's just not going to happen. It's not going to be practicable for school, for transportation, for anything. But if you live in generally the same area and people have a plan for how to make things work, it's going to be time with both parents. You're not going to have somebody that's an every other weekend parent, unless they want to be, unless they travel for work and that's just what they want to do. But for the most part, those plans are not, they're the exception now. They're like really definitely not the rule, because they're not seen as developmentally better. However, age-appropriate parenting plans are really important. You're not going to have like a 3-year-old and have them on a week on, week off parenting plan, because that's way too long for a 3-year-old to be away from either parent. They might be on what's called a 2-2-3 plan, 2 days with one parent, 2 days with the other. and then a 3-day stretch, and then it rotates. So that's just one example. But it's important for you to know schedules can look different. And there's a lot of different things to take into consideration. But I told you if there's a basis for restrictions, that might be different. So there are what we call limiting factors in a parenting plan. Limiting factors can be a finding of domestic violence, substance abuse, mental health, um, anything like that where there is a nexus with parenting. So if you are a recovering alcoholic, but that doesn't impact your parenting, that's not going to impact your case. But if you're, actively abusing alcohol or other substances and there's a nexus with your parenting, that could be a reason for a limiting factor, a treatment requirement, less time with you. Domestic violence can be the same, neglect of a child, abandonment, a lack of emotional ties. A lot of things like that can be a reason for one parent to have less time with the child or restricted time or supervised time. It can also be a basis for one parent to have sole decision making. So those are more nuanced things to look at, but it's important for you to know that that's a real thing. I'm going to talk about child support for a minute because I want to make sure I get to it. And we've kind of talked about a lot of things so far. Child support is generally the last thing that we talk about in a case because there is a statutory formula for child support. You can look at how much the parties make, how many kids you have, and it's going to give you a formula for what the amount of support should be. And then that's going to be allocated proportionally between the parents. So child support, and then who gets the child support? The person with more nights during the month. There can be reasons to have no support if you guys have equally the same amount of time and you make about the same amount of money, or you're equalized with spousal maintenance. There might be no support at that time. It really just depends, but you're still going to need a child support order. Child support order is going to deal with how much the support is, even if it's none. And if it's none, you're going to have to say why it's none. There's going to have to be a basis or the court won't enter it. It's going to have to say who's covering the kids on health insurance. And then there's going to be worksheets that underlie the child support order. The worksheets are going to show basically the math and the deductions on how much people make. Are you giving them a credit for paying the premium towards the kids' insurance, or is that going to be split along proportional share lines later? I could talk about child support all day, but it's not that exciting, so I'll stop. But child support worksheets, child support order are part of every divorce where there's kids. They have to be entered. There's going to be a child support transfer payment from one party to the other based on income. These are the very basics. There's also going to be a proportional share on the worksheets and in the order that is for everything that is not covered by child support. Child support covers basic life necessities: food, clothing, shelter when you're with the child, transportation when you're with the child. Extra things are extracurriculars, out-of-pocket medical, work-related childcare, things like that. All of those things are going to be divided on proportional share basis, given the income that parties make. Post-secondary support, if your child's going to go to college, that is also addressed in a child support order. If your children are younger, that's going to be reserved for you usually to deal with later, unless that's the smart way to do it anyway. So that is a bit about child support. I could talk about a few other things, but I'll take a few more questions if there are any, Gabriella.
Yes, of course. No, we definitely have lots of questions filing in, a lot of it coming from either temporary orders or maintenance. One big one that I see are how are modifications figured post the final? So whether it's for spousal maintenance or for child support, what are the grounds for modification?
Don't go into this thinking you're going to modify your spousal maintenance, because you're probably not. That's the first thing I'll tell you. I'm not going to tell you that you're going to. I'm going to tell you this. I'll tell you the basics. Spousal maintenance can be modified based on a substantial change in circumstances that really couldn't have been contemplated. If you lost your job and you're paying maintenance, and you showed that you tried to get a job and you didn't quit your job, you actually lost it and you can't get another one. Your payments might be suspended for a while. Your payments might be reduced, any number of things like that. But I will tell you this, what generally ends up happening is you get the benefit of the bargain. The person getting the maintenance gets the benefit of the bargain, unless someone becomes disabled or something like that. But they usually will just extend, like if you, let's say, have a few months where you're not paying and a few months where your payments reduced, the amount that you didn't pay versus the original award will be tacked on to the end. So it's not going to change that much. If somebody gets a job later and they didn't have a job when you entered final orders, well, it was contemplated whether they're going to get a job or not. If they won the lottery or something significant really changes, then maybe you're going to get your maintenance reduced. But if it's just like they went back and got a regular job, well, that could have or would have been contemplated. You're not going to get your maintenance reduced. That's not going to happen. Spousal maintenance modification is a very rare thing. It doesn't happen very often. It's not a common motion because it's not generally appropriate. Let's put it that way. I can also tell you uh, temporary orders. Once there's a temporary order, you have to have something significant to change it. It's probably going to be the temporary order until you get to mediation or trial. However, if something really changes and you're paying a bunch of maintenance because someone doesn't have a job and then they get one temporarily, or I mean, they get one while your case is still pending, then yeah, you could go back and ask for a change in support. But you also have to think about this. If you're litigating a case, if you're working with an attorney already, you probably know this. If you're not, you're going to find out. Going to court for temporary orders could easily cost each party between 5 and 10 grand each. And that's not even, I mean, by the amount of time and work that has to go into it, that's not an unusual thing. So not at all. And so you need to know that if you can negotiate things, that's always a lot smarter. And then you have to look at it. If we can negotiate making a change here, we should. If we can't, how close are we to mediation? How close are we to trial? Does it financially make sense for me to go back and spend another 10,000 when there's no guarantee on what the outcome is going to be? I don't know. It depends on your individual circumstances, but it is expensive to go to court. That's my point. Sometimes you have to do it, and sometimes it's the smartest thing that you can do because you're going to come out of there with either some kind of stability, security, resources, and you have to do it if you just can't agree. But it's expensive and it's uncertain. So it's never the best way to go. Let's put it that way. All right, what's next?
All right. We have several questions asking about disability and retirement. So if
Mhm.
there was anything that you could do to expand on disablement, how that affects, and also retirement.
Retirement. I mean, I don't know. Oh, I guess somebody's probably asking like if your retirement age. Okay, if your retirement
Mhm.
age, let's say you stop working, you're 55. If you have the resources to do it, and that was like part of your plan, and you guys have a lot of money, fine. But if you don't, and you're just like, I'm going to retire when I'm 55, it's going to be expected that you work till at least 62. So you're not going to get out of maintenance by retiring at 55. Like, that's not going to happen if you're the person who's going to pay maintenance. Bottom line is, when looking at your asset and debt division, it's going to be important to look at how many working years you have left. So what I mean by that is, if you're 62 or 65, there's not going to be an expectation that anybody's going to keep working, right? So you're going to look at how much are people drawing on Social Security? What are the other assets? What's the big picture? But it's not going to really be about income. It's going to be more about benefits. What's taxable, what's pre-tax versus post-tax? And then that's going to factor in a lot into, can you draw on these retirement assets with or without a tax benefit? Any number of things that you're going to want to know. So your age really factors into what makes sense with your asset and debt division with pre and post-tax assets, what makes sense with spousal maintenance. If we're looking at one person having a lot larger Social Security benefit than the other, any number of things like that. So being retirement age at divorce, it changes the picture just a little bit, but it's really just a host of different considerations. What was the other question?
We have several inquiries that are about whenever they go, whether it's on FMLA, and they're the high income earner, now they're expecting surgery. We have someone else who is disabled and they're using some of their disablement check to pay for some of these expenses related to legal services.
Mhm.
So what kind of things are taken into consideration for either surgeries or disabled people throughout the process?
Well, if you're on disability, here's the thing. If you're disabled, if you're on disability, whether it's full or part-time, if you're on part-time, then you can only work part-time. You're not voluntarily unemployed if you're working part-time. If you're on disability, you're not voluntarily unemployed or underemployed, you're disabled. That's what you've got. That's it. If you're on FMLA and you have surgery and that's like a real thing and you can't go back to work and you may have short-term or long-term disability payments depending on your situation. Or maybe if you're out and you're getting SSDI or whatever it is, that's what you're getting. No one's going to force you back to work if you're actually on disability or if you have a surgery coming up. So, yeah,
Wonderful. And then I have one that's, is student loan debt considered community debt?
that's such a good question. Yes. And let me explain that though, because there is case law on this that you need to know. You don't need to know the case law, but you need to know the rhyme or reason behind it. So let's say I go to law school during my marriage. Oh, here's a fun fact. I did. I went to law school during my marriage. I'll use my situation. I go to law school during my marriage. So there's a whole bunch of debt from that, like a lot of debt. And then I get divorced literally almost right after that. So that debt and my spouse went to medical school. So we had a lot of debt, right? So technically, my law school debt was community debt. If you really wanted to get down to it, you would think that that would be a debt that we would both share because it was earned during the marriage, right? No, wrong. The reason why it's wrong is that my former spouse was never going to realize the benefit of that degree. If we had been married during my undergrad, then maybe they would have realized the benefit of that because it got me into law school or it got me another job or whatever. But that law school debt, if the other party, if you get divorced like right after it's over, then so if you get divorced literally like right after it's over, then the other party's never going to realize the benefit of it. You are. So it's likely that you're going to be allocated that debt. But if you have a degree, no matter what kind of degree it is, and you stay married and you get a job because of that and years go on and you guys are still paying on the loans, that's community debt. The community benefited from it. So that's a really important distinction for you to know. Likewise, if you have separate property loans, let's say I had finished law school and got married right after that, or I'm married now, to my current husband, and he has nothing to do with if I had law school debt still, he would have nothing to do with that. It would be my separate debt, even though the community that I have now is benefiting from it. So if it's before marriage, it's separate. If it's during marriage and it's student loan, it's presumed community unless the community was never going to benefit from it. So I have a few more things I can touch on, but
Of course.
I can take questions if there's a couple more. I'll take two more questions if there are any, and then I'll talk about a few final things.
Of course. I think this one's a good one, is relocation when considering when the primary custodial parent wants to move to a different state, how does that get negotiated or put into even temporary orders, etc.?
Well, if the other parent wants to move and you don't want them to, you should get a temporary parenting plan as soon as possible. The reason why is that any parenting plan includes Washington's relocation statute. Once there's a parenting plan in place, anybody that has 45% or more of the residential time is required to give a 60-day notice to the other parent. And the other parent has 30 days to respond and object if they want to do it. So you can't just move. You can't just up and move. Okay. So if you're in the middle of a divorce too, here's another really good thing. If you really want to move and you know that that's going to happen, you really probably should negotiate it during your divorce. Otherwise, if you go through the whole process and you've settled on a parenting plan and then you knew that you wanted to move and all of a sudden you try to move, 6 months later, that's going to be a lot harder for you. It's going to be a lot harder for you because it's going to be like you just negotiated this parenting plan. You could have or did contemplate this before and you didn't do anything. And that's going to be really hard for you. Washington's relocation statute has a number of factors. So you're going to go down a long list of factors in evaluating whether the court's going to approve a move. And really, if you want to move out of state, you need to have a strong reason to do it. And really, the person who's objecting is going to have to show that it's more detrimental for that child to move with the parent than it is for the contact to be broken with the parent that's staying behind. It's a lot, but let's put it this way. There is a presumption, and this is one thing you do need to know. There's a presumption that the primary parent can make the move. So we talked about like every other weekend schedule. If you're a parent that is only having every other weekend, you don't have that many nights during the month, and it's going to be presumed anyway under the statute that the primary parent can move. Okay. If you are on a 60-40 parenting plan or a 50-50 parenting plan, it's going to be very difficult for that move to get approved for the child because it's going to be a lot of time and a big change to the schedule and a lot of time away from a parent that a child is used to having a lot of time with. And every other weekend parent, there's ways to work around that. And a long distance schedule is going to give the other parent who is not moving, it's going to give them a lot of the summer and a lot of the breaks, right? So if you're in the divorce context and one party wants to move, that issue, my recommendation is raise it during the divorce. You're not gonna be raising it for a while after. If you don't want the other party to move, the more residential time you can get, the better, because that will make it harder later.
Wonderful. I'll go ahead and let you finish anything else you have, Michelle.
Okay. All I was going to say at this point is this. You should really think about next steps if you are early on in the process. I like to tell everybody the basic financials that attorneys need because then it won't come as a shock to you. So you're going to get asked for these financials and you're going to get asked for them more than once. Okay. So you're going to get asked for at least your last 6 months of um, at least the last 6 months of pay stubs that you have. I recommend a year because somebody asked a really smart question earlier about do bonuses factor in? And if I have a year of pay stubs, I get a better idea of when your bonus hits, what the whole deal is. But at least 6 months. The court's going to require 6 months for a motion. I like to see a year if you have it. The last 2 years of tax returns, personal tax returns, and I don't mean just like the summary pages, like the whole thing with all the schedules and your W-2s. If you have a business, you're going to need the last 2 years of business tax returns as well. And here comes the labor intensive part. You're going to need 6 months of statements for every account you have an interest in. And if you don't have access to these, if you're not the record keeper in your family and you don't have access, don't worry about it. But if you do, that we'll have to get them from the other party. But if you do, organize your financials and get them together. It's going to save you time and money rather than having an attorney organize them for you. 6 months of bank accounts, 6 months of mortgage statements, 6 months of taxable accounts, 6 months of retirement accounts, and organize them, 6 months of credit card statements, get it all together. Bank accounts, Bank of America, last four, 1, 2, 3, 4, Chase, 1, 2, 3, 4. And then inside of there, January, February, March, just really do a good job organizing your financials. It's going to help you in the long run. You're going to have to produce these documents at some point, and getting started on that is really going to help you. So the best thing you can do too, this really, I say this because I know you might not think it, but we really don't want you to waste your attorney fees. We really don't. Attorneys don't. At least most good ones that I know don't. We don't want you to waste your attorney fees. And so I can tell you, if you're working with an attorney, send one email in a day rather than 5. You might have 5 questions, put them in one email. If I'm looking at an email from a client and I've got 5 questions, doing that all at once is going to take me less than half of the time, less than half than if I have to stop 5 times during the day and answer 5 different emails. It's going to take me a lot longer and it's going to cost you exponentially more. Be smart with your communication. Wait and think about, do I need to ask this question? If you do, great. Try to bundle it with another question. If you want to have a phone call with an attorney, think about, do I really need to have this phone call? Or is this something that could be an email? And it's not that we don't want to talk to you, we do, but I find, and I do it too. I mean, you just listen to me talk for a freaking hour, right? I could talk all day. And that would cost me a lot more if I was talking to somebody for an hour or even 2, than if I ask my questions via email, or like we have a case status app where you can send quick questions. And it's not because we don't want to talk to you. It's because we want you to have money for times that you need it. I want you to have money for that meeting before mediation when you really understand what's going on. When we're talking about temporary orders, when we're working on your declaration, when we are, preparing for a deposition and preparing you and doing all of these things. It's better to have money for that than being like, what do I do if my spouse is 10 minutes late for the exchange? What do I do if I want to move the exchange from here to there? What do I do if, just anyway, I'm trying to say pick your battles, and I'm trying to say just be smart with your resources. We don't want to burn through your money. We want to have it last for you and to have you use it in a way. Legal services are expensive, and attorneys don't like to talk about that. But, I'll tell you this, and I don't usually say this, but I feel like saying it today. Like, Before I went to law school, there's no lawyers in my family. Like, I didn't even know what that meant. And I remember one time my parents having to hire a lawyer for some kind of real estate thing, and it just seemed like this astronomical amount of money. They didn't really know what was going on. I didn't know what was going on. I saw how confusing and stressful it was for them. And I was in law school at the time, and I was just like, oh my gosh, I had no idea. Because when you're in law school, you have no idea either. And so now when I think about attorney fees, I think about it like, what if it was my parents? You know, you want it to be clear. You want that money to be for questions you really need, not just because you're confused about the process. Sometimes putting things in writing is a lot better, or having someone do it for you to help you get clarity, because that money can go very quickly. And working with an attorney is something you probably don't do often, and it can be scary and confusing. It really, really can be. I just want it to go as well for you as possible. Divorce is stressful. This is a life change for you, whether you want it or not. And I wish you the best. So thanks for coming. Thanks for asking questions. We do, Gabrielle can tell you too when I hop off here, but we do a series. Every month we do 2 webinars. We also do a monthly meetup group online, in person once a quarter. And there's a lot of resources available online. I feel passionately about giving people more information than less. So hopefully that's helpful to you. Thanks so much and have a good day. Bye-bye.
Thank you, Michelle. Thank you everyone for joining us. I'm sorry there were some questions we weren't able to get to. An hour goes by really quickly. We will have this video posted tomorrow at 9 o'clock on our YouTube channel, so feel free to check us out on YouTube. You can go to our website and go to news and resources, and that's where we will have links to our upcoming webinars. The next one we have is next Wednesday, or next Thursday, I'm sorry, October 9th at 1 o'clock, and it is about protection order. So it's Domestic Violence Awareness Month. We are a really big advocate of survivors, of those currently experiencing it. If you or someone you know are going through it, we really encourage you to find resources. Feel free to come on our webinar, recommend it to others that might need it. So that will be available on our website as well. And then, like Michelle mentioned, we do a meetup group typically at the end of every month. This one will be virtual on October 22nd. You can also find that on our website. And so feel free to follow us there. That's another Q&A, more focused session where we're able to have a panel of financial analyst Michelle, home property, Melissa Rosenberg, who's Better You Counseling Services is available, and we answer a lot of questions in a Q&A fashion. So less kind of like today where we're providing a lot of information, and it's more of a roundtable Q&A session. So I would encourage you to join us on our webinar or our meetup group to ask those additional questions. If you need anything, always feel free to reach out to us. That's Michelle's email below, and you can also reach us at contact@delinolaw.com. If y'all need anything else, feel free to reach out to me. I'll be here for a couple of more minutes. So if you have any chats or anything or an email that you want me to reach out to, please feel free to send that over. And feel free to screenshot the stay in touch, and we will talk soon. Thank you again for joining. Have a great day.